Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the latest episode in the HW Funds podcast series about anti-money laundering and counter-terrorism financing. HW Funds is the investment funds team of the national law firm Hall & Wilcox. My name's Langton Clark, a partner in HW Funds, and I'm delighted to be your host for this series and today's episode. In our last episode, we talked about the Know Your Client obligations, one of the fundamental components of Australia's AML CTF regime. And there can be a fair bit of work to identify and verify clients, which might, in the case of some people, take a discrete set of resources, human and otherwise, dedicated to fulfilling those obligations. So a natural question is, must I do this personally, or can I outsource those obligations and that process? And I'm delighted to be joined today by my colleague Elliot Stum, a partner in the HW Funds team who's an expert in AML and CTF, and he'll talk to us about outsourcing various obligations under the regime. Hi, Elliot.
Hey, Langton. Thanks for that kind introduction.
So straight off the bat, can you use outsourcing to help meet your AML CTF obligations?
Yeah, absolutely. And people outsource for a range of reasons, including to manage the cost of compliance with the AML CTF laws and to decrease the administrative burden associated with compliance. People utilize service providers to help them out in this regard all the time. Before we go much further, though, I just want to touch briefly on what outsourcing actually is and what it means, at least for the purpose of today's discussion. So outsourcing, as a general principle, refers to having someone do something else on your behalf. And in the context of the AML CTF laws, this can capture a range of things like having someone else, like a law firm, prepare your AML CTF program. But generally, when people are coming to me and ask and talk about outsourcing, they're talking about having someone help them with the undertaking of the relevant customer identification procedures.
Yeah, and that's the type of outsourcing I'm particularly interested in discussing because our clients often ask us, and it's common for professional service providers to provide this service, that collection and verification information for clients that they need to know. So how does that work?
Well, the AML CTF laws do not disrupt the general principles of agency. You can engage another person to carry out those applicable customer identification and verification procedures on your behalf. The use of a service provider broadly involves, engaging a service provider to collect the required information and documentation on your behalf. Often as part of this service, they also perform checks and undertake other matters in relation to the customer. And then they ultimately provide that information to you in a report or otherwise that you then refer to before providing a designated service to that relevant customer. When we're talking about outsourcing these procedures, the most important thing to appreciate is the entity that has the obligations under the AML CTF laws will remain legally liable for any breach of those obligations, even if they're outsourced. So it's important you take steps in this context to manage any risks of outsourcing and ensure you have appropriate oversight of your providers.
I think that's a really important point because I think a lot of clients would think by outsourcing, they've hived off the responsibility to someone else. So how do clients manage the risk you've just mentioned in this context?
Yeah, so really at the most basic level, before you engage a service provider to help you out in this respect, you should conduct due diligence on that provider and make sure that they're qualified and experienced and have the resources and capability to provide those services to you effectively. Once you've found the right provider, you really want to make sure that there's a written and legally binding agreement in place. The terms of that agreement should really accommodate them providing the services that they're going to provide in a way that you can rely on them and be satisfied that you're meeting your obligations under the law. The agreement should really specify the services to be provided and the standard to which they are going to be provided. You want to include oversight, monitoring and reporting provisions in there as well as some sort of quality assurance mechanisms, and that could involve, periodic audits and things like that of the services they're providing. And you also want to make sure that those agreements include appropriate liability and indemnity provisions. You've also got to have regard when you're documenting these types of arrangements and using a service provider to, restrictions and requirements around information sharing, particularly in the context of the privacy laws and the tipping off provisions in the AML CTF laws. And you also want to think about your record keeping obligations. So with AML CTF, risk identification, assessment, mitigation and management is really at the heart of a number of these obligations, and it's important your outsourcing arrangements and your reliance on the services provided by outsourced service providers are done in this context. And as I mentioned before, Langton, it's really important to appreciate the entity with the obligations under the laws remains legally liable for any breaches of those obligations, even when someone else is helping them. But there are circumstances where you can rely on customer identification and verification procedures performed by a third party, and in doing so, actually have the benefit of a safe harbour from liability for isolated breaches.
Can we dive into that a bit more? So when can a client rely on the customer identification procedures carried out by a third party and get the benefit of that safe harbour you just mentioned?
Yeah, so I mean, reliance in this context, it's not really outsourcing that we're talking about. I mean, it kind of is in the general understanding of what outsourcing is, but you're not actually having someone else perform the obligations on your behalf. Really, what you're actually doing is relying on someone else's performance of their own obligations in respect of that customer. So in certain circumstances, you can rely on customer identification procedures undertaken by other reporting entities as well as regulated foreign equivalents. In the context of AML, these people are called reliable third parties. So in terms of reliance on the procedures undertaken by these reliable third parties, there are two basic options that you've got. You can rely on it as part of an ongoing arrangement, or you can do it on a case-by-case basis. In terms of the ongoing arrangement provisions, the first thing and the most important thing is that you've got a written agreement in place with the other person that relates to your reliance on the applicable procedures carried out by them. You've got to also make sure that at the time you enter into the agreement, you've had reasonable grounds to believe that each of the requirements prescribed by the law are met. And while the agreement's in force and you've complied with the relevant requirements and the other requirements of the law are satisfied, and you've obtained the requisite information around a customer's identity from the other person, you're taken to have carried out the applicable customer identification procedure in respect of the relevant customer and the designated service that you're going to provide to them. So that's the ongoing arrangement type provision. In terms of reliance on a case-by-case basis, if another person has carried out applicable customer identification procedures and you've obtained from them information about the identity of the customer that was obtained by them, you'll effectively be taken to have carried out the applicable procedures yourself. And I mean, in order for this to be a case, it assumes, of course, that you've got reasonable grounds to believe that it's appropriate to rely on the procedure undertaken by someone else. And you've had regard to the risks that you might, reasonably face that the provision of the service might involve, if it might involve money laundering or the financing of terrorism. And the key thing here with these different options is that you satisfy certain prescribed requirements of the AML CTF rules. But if you've done that, then you've taken to actually have carried out the applicable customer identification procedure in respect of a customer and designated service, and you can generally have the benefit of this safe harbor that I mentioned.
It's an important point you raise, though, that the clients are still going to have to be satisfied they've got reasonable grounds to believe it's appropriate to rely on the procedure. So you can't just throw your hands in the air and say someone else is doing it. So could you elaborate just a bit more on the requirements that need to be satisfied in the context of the ongoing arrangements particularly?
Yeah, so as I sort of mentioned before, that the heart of this ongoing arrangement concept is the need for there to be a written agreement. The AML CTF laws prescribe certain requirements around that agreement, one of which is that, obviously it needs to document the responsibilities of each party. It needs to enable you to obtain all the KYC information before you actually provide a service to the customer. And it's got to enable you to obtain a record of the actual procedures undertaken by the other person. In terms of, enabling you to obtain this record, it can either enable you to do so immediately, because there could be, under the terms of the arrangement, some sort of, management of relevant document or electronic data process that's been agreed between the parties to enable, one party to provide the identification and verification documents to the other. Or if you don't have that sort of arrangement in place, you need to be able to obtain those procedures as soon as practicable following, a request that you've given to the other person. You mentioned before, like this idea of risk in this context. So it's not just having, a written agreement in place that you need to do to get the benefit of that safe harbor. You also need to determine the type and level of money laundering, financing, or terrorism, or other serious crime risks that you might be expected to face when you provide those services. You've got to have a think about the nature, size, and complexity of the business of the other person that you're looking to rely on, the procedures undertaken by them. You've got to think about what products do they offer, their service and delivery channels, and the types of customers that they deal with. And you've also got to look at or consider the level of money laundering and other risks in the countries in which they operate. I mean, typically in Australia, they'll be Australian entities, but as I mentioned before, a reliable third party can also include a person regulated by AML laws in another jurisdiction. So in addition to having this sort of agreement and having had to have undertaken those sorts of risk assessments, you've got to actually carry out regular assessments of the requirements prescribed by the law. And you've got to make sure that the person that you've entered into the agreement with is continuing to meet those requirements. So the assessments, they need to be done at regular intervals, and you've got to have regard to certain things when you're determining the appropriateness of those intervals. But in any case, you've got to do a regular assessment at least every 2 years.
Yeah, great, Elliot. Thanks. So are there any other caveats to this concept of a safe harbour that clients should be aware of?
Yeah, so I mean, you do get this benefit of a safe harbour, but I guess you've got to appreciate that it only really operates in respect of isolated breaches of the customer identification procedures. It doesn't sort of operate in respect of all obligations you've got. It's just around that customer identification procedure that you're relying on the other person having undertaken. So you do remain responsible for remediating isolated breaches when they occur. And if there are isolated breaches, you've got to remediate them as soon as possible if they do occur. But you also remain responsible for any systemic breaches that occur where a person would not consider that the arrangement complies with the AML CTF laws. So this kind of feeds into this idea that you've got to review the arrangement regularly. So if reliance under an arrangement with a third party doesn't meet the requirements, you're really not doing that ongoing arrangement exemption, not relying on that one. Really what we're talking about there is case-by-case reliance, and you've got to make sure that you comply with the relevant requirements of those provisions in order to get the benefit of the safe harbour. So just as an example, if you were to become aware that a third party doesn't actually have appropriate AML CTF systems and controls, or if you become aware that they're failing to carry out customer identifications procedures to a agreed standard, there you've got systemic breaches, and you need to not just continue to rely on that agreement that you've got with them. You need to consider what you need to do yourself to ensure that you don't breach your obligations in respect of any customers that might be referred.
Thanks, Elliot. We've got clients who will often refer to parties like registry services provider as the one that's carrying out all the know your client verification. But what are the types of entities you can enter into ongoing arrangement with to get the benefits that you've just been talking about?
Yeah, so I mean, you can only enter into these arrangements and get the benefit of the safe harbour if you're entering into it with what is referred to as reliable third party, which is a person that's subject to and required to comply with the AML CTF laws. Service providers are the kind you mentioned, like registry or fund administrator service providers, aren't typically subject to the AML CTF laws themselves. So you can't rely on these ongoing arrangements or safe harbour provisions in respect of agreements with them. That's just a basic agency appointment that I spoke about earlier, where you're using one of those service providers. In terms of the types of entities that we see these arrangements being entered into, really it's pretty common for us to see these and put the agreements in place in the context of referrers for a fund manager. So a fund manager might have a relationship with a financial planner or wealth advisor that may from time to time refer prospective investors to a fund manager. Typically there's sort of like a referral fee type arrangement in place in this context. These sorts of arrangements are typically documented in a referral agreement. Financial planners are actually typically reporting entities. They've typically got obligations under the AML CTF laws. So if they do, then they are a reliable third party, and they're the sort of person that you can enter into one of these arrangements with. And as I mentioned, these sort of referral arrangements are typically documented in referral agreements, and we often incorporate these ongoing arrangement provisions in those agreements. And from a process perspective, the way this kind of works is that before referring someone to the fund manager, the planner or wealth advisor, or the referrer must have completed the relevant customer ID procedures for the person that they're referring. They then refer the person to the fund manager, and at the same time, they give the required information to the fund manager. And then the fund manager ultimately, issues interest in a fund or what have you to that customer. And in doing so, they get to rely on that safe harbor.
So you just mentioned providing the information to the fund manager. That kind of seems to defeat the purpose, doesn't it?
Not really. So I'll just give you a bit more information about that. So it's not really all documentation and information that the referrer or the reliable third party needs to give you. It's only information about the identity of the customer that was obtained by them when they carried out the procedure. So there's no need to, for example, give verification material like copies of trust deeds, driver's license, and things like that. So it does drastically simplify the onboarding process of a customer. And I think it's important to appreciate really when you're thinking about setting one of these arrangements up is that it's not just useful for the fund manager and the referrer. I mean, we've got to note that the referrer, by having one of these arrangements with a fund manager, doesn't need to provide documents and things like that. They can just give information only. But it's also like really useful for customers and your prospective investors. So it's really burdensome, as I'm sure everyone can appreciate, for clients and investors to complete customer ID procedures a number of times. They've got to give quite a lot of information, supporting documents and so forth. People get pretty sick of the idea that they have to do that for every single fund that they invest into. So if you've got one of these arrangements in place, not just, it doesn't just make your life easier and a referrer's life easier, but it also makes the life of your prospective investors easier as well.
Yeah, absolutely. I agree. It can be burdensome. We do hear that from clients very regularly. So, Elliot, thanks so much for your contribution to today's episodes and your insight on outsourcing obligations under the AML CTF regime. And thanks everyone for listening to today's episode on the podcast series. As always, please get in touch if you've got any queries. You can contact us via our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, then please rate, review, or follow our podcast wherever you get your own podcasts. Thanks very much.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.